So we get a lot more inquiries on the 482 visa pathway. I just want to break it down into one video so that you can talk to your employer with confidence. Welcome back to my channel. In this video, I'm going to cover what kind of things that the employer needs to know before they commit to sponsoring an employee. If you are an employee, what are the things that you should also consider? Without further ado, let's get started. Hi, if this is the first time you come to my channel, my name is Johnny. I'm a migration lawyer in Sydney and I post daily content on TikTok, Instagram and YouTube Shorts in order to help you to get PR faster. Now, we all know the migration policy has changed dramatically in the past couple of years, and the government is obviously phasing out the point-tested migration pathway and leaning more significantly heavier on the employer-sponsored visa program. So we get a lot more inquiries on the 482 visa pathway. So a lot of people ask us, what are the stuff that we need to know before we sponsor an employee? Or the employee comes to me to ask, hey, my employer is keen to sponsor. They sent me to ask you, what are the things that we need to know? So I just want to break it down into one video so that you can talk to your employer with confidence, or you can even show this video to your employer so the employer knows more about it. Of course, if you want to have a chat, just scan the QR code and reach out to us on WhatsApp. And also we have email, etc. And hit the link in bios in order to reach out to us, and we'll be able to help you out from there. Now, there are so many things that we got to cover, so sit tight and wear a seatbelt. Number one is the legal stuff. In order to sponsor someone, the employer will need to decide what kind of visa it is. 482 is a very common skills in demand visa, which is the name, and it allows an employer to sponsor for a maximum of 4 years in one visa. And 482 visa is basically the backbone of the whole Australian work visa program, and it allows the employee to work with you as a full-time worker. Of course, you got a sponsor, and in order to sponsor the employee on a 482 visa, and also the 482 visa, they have no age requirement, and also for a lot of occupations, it doesn't have skill assessment requirement. So that is a lot faster to get through, but the process of getting 482 is actually a lot more procedural. Number one is, as an employer, if you decided to sponsor on a 482 visa, you need to get a standard business sponsor, which is a qualification you apply with the Department of Home Affairs, basically saying, putting your hands up, saying, hi, I'm a legally operating business in Australia or somewhere else. You can be foreign as well. I'm a legally operating business and I want to start sponsoring someone. I have no adverse information. I pay tax and I do all the good stuff as a company. So if the government is happy with that, then they give you an SBS. And once that's done, you can formally lodge a nomination. Depending on your employee's nationality, the passport that they hold, they may need to carry out something called labor market test. What labor market test is basically you're trying to prove to the department that, hey, I've tried my absolute best to source local talents to fill this headcount, to fill this role. Unfortunately, you have posted ad for 28 days on different websites, you list out all the things, but you just couldn't do it because there's no suitable talent. This is called labor market test. It's called posting ads. There are very specific and rigorous requirements that you have to follow. Make sure you talk to your migration lawyer or migration agent to get this one done perfectly. Otherwise, if the nomination is refused, you're going to lose all the investment. All right. The other thing you got to be aware of is the other deciding factors from the department. Number one, what is the salary you're paying to this person? As of today of this video, the minimum salary on the 482 core skilled occupation list is 76,515 plus superannuation. But it doesn't mean that you should pay 76,515 to your employee in order to meet this requirement, because just meeting at the absolute bottom does not make sense. Normally, you pay a bit more, maybe 77 or 78, but regardless, the rule of thumb is this is just the absolute minimum. If the market salary is higher than this amount, you pay the market salary. The other thing is whether or not you have another employee in the organization who is also doing the same job. If as someone else who is an Australian citizen or permanent resident who is carrying out exactly the same job responsibility, then this foreign employee must be paid at the same scale. But how you define it is entirely up to you. Whether or not these Australian employees, they do something a bit more so that they get paid more, or the foreign employee, is less skilled in certain aspects. So it's done on a case-by-case basis. The other thing that you got to pay attention, the percentage of foreign workers in your workforce. months. There's no hard and fast rule on this. There's no 50% cutoff or 20% cutoff. It is basically designed this way to promote flexibility, so that it is currently assessed on a case-by-case basis, and the department will look into the industry, look into the nature of your business operation to determine whether or not it makes sense to exceed a certain percentage. For example, if you have 20 people and you're trying to sponsor one person, that's fine. Most of the time it's okay. But if there's 20 people working for you, but 80% are foreigners, and you try to sponsor all 80% of them in one hit, probably not. It depends on the industry. Not saying there's a hard and fast rule saying no, that's actually absolutely impossible, but it depends on your business operation. If you're in the mining industry, maybe it makes sense. 1,000 miners, like 90% of them are foreigners, fine. So it depends on the industry. There's the other thing that you got to pay attention to is the Skilling Australian Fund levies. These are levies that you got to pay to the Australian government if you want to sponsor an employee, sponsor someone on a 482 visa, and that is $1,200 per person per year. If your revenue is less than $10 million a year, if it's over 10 million, then it's $1,800 per employee per year. When it comes to per year, it's actually paid in one lump sum, because you will need to put your hand up and confirm how many years of the 482 visas you want to sponsor for. Say if you are only wanting to sponsor 2 years, then you pay 2 years of that levies, but most of the time we recommend at least 3 years for the employee. Last but not least, there's no obligation for you to transfer this person to a 186 permanent residency visa, but of course, in order to retain your workforce, it's always a better idea to have a very clear and transparent policy, and also commitment to transfer your employee to the 186 transition stream. In order to qualify for the permanent residency pathway for the employee must be under 45 years old at the time of submitting the 186 visa. So that's something you got to pay attention to it. If you're sponsoring under labor agreement, then it depends on the labor agreement. But the general rule of thumb is 45 years old is a hard cutoff. So if you really want to give your employee a permanent residency pathway, then you got to make sure at the time the employee is eligible to apply, he or she is under 45 years old. And also, the employee has no real legal obligation to stick on with you for the whole visa period. So say if you're sponsoring this employee for 3 years, but if you decided to this is no longer the right fit, you can still make the employee redundant or terminate the employment in accordance with the Fair Work Act. There's nothing stopping you from doing so, and the right is mutual. If the employee doesn't want to work for you like halfway through, then the employee can resign and move on. Of course, that the visa condition in the 482 visa is to ensure that they work only for the employer that they sponsor, with some exemptions for medical industries, but for most of them, the employee must only work for you during this visa period. But of course, once they have resigned it, this no longer apply, because the employee will have 180 days to find a new employer to sponsor their visa. And for you, for the employer, there's no refund on the levies and all the other stuff that you put in. So make sure you treat your employees right. Don't just treat them horribly, not providing a PR pathway if you think that I'm sponsoring them, or I will let them know on the last minute. It doesn't work like that. Always try to plan on your 186 pathway for your employee, so the employee can work for you like maximum effort during the visa period when they're with you. Last but not least, when it comes to the employer, it may sound like, hey, I'm paying all this money but not securing my employee. That is correct. It's normal to have this feeling, but the way to retain your employee is to treat them right. When it comes to the visa condition, they are also obliged to work only for you. So that means they cannot accept a part-time role somewhere else. They can't drive Uber. They can only work for you, and you become their only source of income. And if they decided to resign, they only have 6 months to find a new employer. If they couldn't secure it, they will need to depart Australia, or if their visa ends earlier than 180 days, then that date as well, because that's the visa expiry date. When it comes to the employer, that's also something that you can also consider when you transfer the employee to 186, which is also a new application. For that particular transfer, it will take usually 10 to 18 months in order to process it. Usually we will expect around 14 months of processing time, and during this 186, like the PR transition period, the employee, if their 482 has expired, they will get a bridging visa to continue working for you, having the same visa condition situation, and it will make them very vulnerable during that period of time. And if you're an employee watching this video, also make sure that during this 18 months you're only on a bridging visa, and for something happen, if the employer decide to back off or employer decide to make you redundant, then you're in a very awkward situation. So that's something that you got to pay attention to. I hope this episode has been very helpful. The goal for this episode is to ensure that you understand the employer and the employee side of things as to what are the employer and employee obligations, visa conditions, etc. This video does not intend to provide a full-on legal advice because there's so many nitty-gritty stuff, but it should provide a very good talk points for the both of you to kickstart this conversation. And if you got any questions, there's a QR code here, and you feel free to scan it and talk to us. If you got to this part of the video, hit the subscribe button, like, share with your friends or share it with your employer or employee, and let's have a chat about the employer sponsored visa program. And just now I only talked about the 482. In my next video I'm going to talk the same thing about the 186, and I'll see you in the next video.